John Ackerman for Convention of States, Indiana. In this episode of COS Basics, I'm going to consider the truth that the scope of an Article 5 convention can be limited. In fact, it will be limited. And as I've said before, much of what I'm saying is not original with me. You can find it on conventionofstates.com. This time, Rita M. Peters, Doctor of Jurisprudence, writes, "The scope of an Article 5 convention can be limited." Article 5 naysayers claim that at an Article 5 convention, our entire Constitution will be opened up for surgery, including the Bill of Rights. There goes freedom of speech, there goes your Second Amendment, etc., and so on and so forth. Well, this is wrong as a matter of fact, precedent, and logic. First of all, fact. More than 400 applications for an Article 5 convention have been filed with Congress. The reason we've never had one is because there have never been 34 applications seeking a convention for the same purpose. This fact demonstrates that the purpose or scope specified in the applications does matter. And only when 34 states agree on a given topic will the convention even be triggered. Number 2, precedent. When states convene in convention, they always have a particular purpose and a specified topic. For example, the purpose of the 1787 convention, commonly called the Constitutional Convention, was to, and get this, quote, render the federal Constitution adequate to the exigencies of the Union, close quote. Third, logic. Official meetings of any kind always have a stated purpose. We call it an agenda. There is just no other rational way to conduct business. The conclusion of this, the fact, the precedent, and the logic, the conclusion is that the Convention of States project application limits the scope of an Article 5 convention to proposing amendments that, 1, impose fiscal restraints on the federal government, 2, limit the power and jurisdiction of the federal government, and 3, set term limits for federal officials and members of Congress. States cannot broaden the topic that was identified in the 34 triggering applications. Contrary conclusions have no basis in fact, law, or history. And so I repeat Attorney Rita M. Peterson's point: the scope of an Article 5 convention can, and I will say will, be limited.